thanks to Laura and thanks to Dr. Yu. I'm very happy here today to share some thoughts and ideas about collecting your debt in China. And generally speaking, I understand from Laura's sharing and speech, there are many things in common between China and Italy. And since as far as I understand, China's law system is generally based on civil law system in many aspects. So there are many things in common between China and Italy in the law system here. So since we have many things overlapping with each other, I understand, I will not spend too much time on the contents that Laura has already introduced. And I would like to share some features or special points in the system of Chinese law, okay? Yes. And here at the beginning, I just would like to share some general principles of debt collection in China. And the first is about some typical debts to be collected. Well, since we have many professionals here today as audiences, I understand here all legitimate debts can be collected in China. And the most typical ones include payments under international trade and loans and some other licensing fees of intellectual property like trademark, patent, or something else. And here, the most important principles I would like to emphasize or share is about, first, we need to clarify and target who is the debtor. And just as Laura said, you need to do investigation on the debtor about the information, his name and his assets, his credit or something else. Well, I understand in China, the first thing is to target the standing and the identity of the debtor, because there are many aspects or stages in a transaction, especially cross-border transaction. And you know, in China, some exporters, they send the importer email in name of an individual, and then they send invoice or pro forma invoice in the name of another company, and finally they deliver the goods in another company's name, and even they get payment in a company's name you have never heard of. So here the first thing is to target who is the debtor, who is the one you need to send your attorney's letter or file litigation against with. And the second point is that you need to show to the debtor that we are serious and we can reach you. Because many exporters, they just disappear and evade from communicating with you because they believe that you cannot find me and you have no means to seek debt collection against me in China. So here, engaging a local lawyer in China and tell your debtor in Chinese, saying that our client is serious and he can reach you through me, is really effective to get a bridge of communicating with the debtor, and even later to do some, say, amicable means of communication or later file litigation. And the third part is, just like Laura said, you need to know the credit and property of the debtors. So if it is a debtor without property, sometimes it's meaningless to just go further to collect your debt. And finally, please make comprehensive plan before your action. And as lawyers of China, we are very happy to help our clients to do this. Here, let's go on with some specific methods here about different steps of debt collection. And I fully agree with Laura that generally speaking, the means of debt collection can be divided into extrajudicial means and judicial means. As to extrajudicial means, generally the first step is to send attorney's letter and give an oral notice to the debtor. But as far as I understand, this step is not that amicable. It's a kind of warning as far as I understand, because most Chinese debtors are not that willing to pay the debt voluntarily. So here, the first step, attorney's letter, we have some special purposes here, in addition to claim against the debtor. It is a good way to show we can reach you. And it's a great method to collect evidence, especially about the identity of the debtor. In this way, if you cannot target the debtor at the beginning, you can try to send an attorney's letter and give oral notice to the debtor, and then try to communicate with the debtor through telephone, social media, WeChat, or some other means. And in Chinese law, the recording of telephone communication is somehow effective in most cases as evidence. So if you cannot target your debtor through the written instrument or agreement, in this way, if the addressee of the letter, he recognized that, yes, I'm the debtor, I'm the one who export goods to you, it's a great way to collect evidence about his or her identity, and then you can file litigation against him, even if you cannot target him at the beginning. Okay, so this is something special I understand on the Chinese law. And let's go on with some all judicial means or judicial ways of debt collection, and we just have a quick review of most frequently used means of judicial ways. Here, first, litigation. Through Laura's sharing and our Portuguese friend's introduction, I understand in Italy and Portugal, here Laura has mentioned the injunction decree, right? Yes. And it can be an ordinary instrument, or a document can be executed just very efficiently and quickly. But I understand in China, if you want to get into the procedure of enforcement by using the national power or the power of a court, you need to first get a written instrument, and such instrument generally needs to be obtained after litigation or arbitration or something else. And before you have such procedure, you want to get an instrument that could be or possibly be enforced. That is very, very difficult in China. So such injunction decree, if it exists in China, it's just somehow, how to say, a very, very preliminary document to be enforced. And the properties of the debtor cannot be transferred to you through such document. It can only be frozen or seized, but cannot be transferred to you, or his properties cannot be auctioned through such injunction decree. That is not, I understand that is not possible in China. You need to go through the procedures of litigation or arbitration or some other judicial procedures. So on this prerequisite, we just have a very quick review of China's litigation system. Since China has a 4-level court system with over 3,500 courts, quite many courts. And China has 1 Supreme Court, 32 high courts located in different provinces or provincial administrative regions, and over 400 intermediate courts located in, we say somehow, big cities, and about 3,000 primary or grassroots courts, which hear most cases in China. And most cases will be filed before primary or intermediate courts in China at their first instance. And the vast majority of cases will be closed within 2 instances. So that means the Supreme Court in China hear relatively small number of cases, and most other cases will be closed in local courts, different levels of local courts. As to jurisdiction of the court, about the connecting factor to decide which court has jurisdiction over a case, generally speaking, the defendant's residence has jurisdiction over most cases. And there are also many other connecting factors, but we will not focus on this point today. And about the general process, It is quite common to our professionals. I understand case filing, service of process. We have pre-trial preparation, we have hearing, and finally the judgment needs to be rendered and served to each party. And if you need to appeal, just go ahead for your appeal. And there will be second instance procedure, which is somehow similar to the first instance, but highly simplified compared with the first instance. So still, and here's the point I would like to share, and I'm also enlightened by Laura's introduction that about Chinese law system of property preservation. What does it mean? Well, this picture is, of course, clerks and judges. They just go to the debtor's property. I understand a unit of apartment, real estate. They just seized the real estate by affixing their seal on the door. And but this action is taken before effective judgment is made. So here, property preservation is somehow similar to the injunction decree, I understand, it's described by Laura, but at this step, the court cannot auction the real estate and give money to the creditor. They also cannot transfer such apartment to the debtor, to the creditor. This step is made to freeze the property before the judgment is rendered, but the only purpose here is to freeze the property. We cannot dispose of the property here at this stage. And here you need to provide clues of property to conduct property preservation for the court. If you have no clues, in many cases, the court will not help you to do this step. You need to provide where the apartment is located, where is the property, what is the bank account or something else. And you need to provide guarantee to the court saying that if the action is taken wrongly, if I have to make a compensation to the debtor, okay, I have some guarantor to compensate you. And the guarantor in most cases will be insurance company or banks or some other financial institutions. So you need to provide guarantee to conduct property preservation. And here, this action, the second point on the slide, it can be conducted online, and we will introduce this in the following slides about enforcement, okay? This is a very interesting point, I understand. About court fees in China, it's a progressive rate, and just like personal income tax or something else. And if speaking in short sentences, I understand in most cases, the average percentage of court fee will be about 1% of the claim you made to the court. In most cases, saying about RMB 1 million to RMB 5 million, let's take this as an example. The average percentage is about 1% for cases in this range. And if your claim goes higher, the general fee rate will go lower. Okay. And the top fee, the highest percentage, is about 0.5% if your claim amount is really high, and over the top, the cap of the progressive rate is 0.5% of the claim you made. And arbitration, I think Laura has introduced quite much and very comprehensive way. And I just list some somehow renowned arbitral institution in China. We have Beijing Arbitral Commission and CTAC, means China International Economic and Trade Arbitration Commission, and International Arbitration Court in Shenzhen and Shanghai. These are somehow renowned institutions. And arbitrate, if you want to resolve your dispute through arbitration, you need to have such agreement or clause. And arbitration generally have lower requirements on formality documents and evidence. Here, formality documents means the documents to prove who you are and about your POA. Such documents, arbitration has lower requirements on this. And the process or proceeding of arbitration is to some extent similar to litigation in China, but it is much more flexible. And if we have opportunities in the future, we can share more on this. And here also, property preservation is available in arbitration. You can apply to the court to conduct property preservation through arbitral institution. It is possible. So whatever the resolution, the method of resolution you adopt or you choose, just remind yourself of the possibility of property preservation. Okay. And arbitration is not possible to be appealed. The award cannot be appealed in China, and it is very, very hard to set aside or revoke the award. So pay all your efforts to the proceeding. You have only one chance in arbitration in most cases. And here, settlement and mediation is somehow also a very interesting method in China. And here settlement means you just try to settle the dispute with the opposing party without the help of court or arbitrators. And mediation means that they just intervene within your proceeding and try to help you, both parties, to reach a settlement agreement. And all such procedures can be conducted before, during, even after litigation or arbitration. And here I understand after litigation or arbitration is quite puzzling to our clients, because in China, even if you have get into the procedure of enforcement, you can still try to settle or mediate with the opposing party, because some of their properties cannot be found by the court, even through procedure of enforcement. And if your debtor is willing to just reveal something they conceal, it is possible to consider the possibility of settlement still. And settlement and mediation are truly, truly welcomed by judges and arbitrators, because by doing so, they can just save the time and energy of writing a judgment or arbitral award, and it's risk-free for them to give their somehow a conclusion or something on specific law issues. So it is safe for them, and they are the love of judges and arbitrators, settlement and mediation. They will try every effort to conduct this. And finally, please pay attention to the enforceability, or whether the conclusion of settlement can be enforced or executed, as Laura mentioned here, because if you reach a settlement with the opposing party without the witness and help of court or arbitrators, and you did not get an instrument from court or arbitral institution recognizing the result of settlement, such agreement cannot be enforced by the court. You still need to go to the court or arbitral institution to review this agreement, saying, right, correctly, you have reached agreement, it is effective, and the debtor did not perform such agreement. I will give you a judgment or award, and then you can go to enforce this instrument. It is very time-consuming here. So we would like to recommend our clients to try to conduct this procedure with the help of court, with the witness of the court, and get a court settlement statement or something else from the court or arbitral institution. Later, this instrument can be enforced directly if the debtor fails to perform. So please just pay attention to the enforceability. Here, I understand the most interesting part of today's webinar. about in Chinese side, I understand it is enforcement. Why? Generally speaking, the general steps of enforcement in China is very, very similar to Laura's introduction in Italy, and the different steps and the ways we have many things in common. And here, I would like to say that first, enforcement is the power and the duty of the court only. The parties, you cannot try to enforce something privately. It is not allowed. You need to rely on the court to do enforcement. And the method, which just skip the first 2 points, has already been introduced, which has already been introduced by Laura. And the third method, the Chinese court, they can restrict unnecessary consumption or high consumption and other acts of the debtor if they fail to perform. For example, the debtor cannot travel by air, by high-speed train if they have some obligations fail to be performed. That is quite interesting because Chinese court, they have an online system of enforcement. The words we just point out in red, we highlight in red about online system of enforcement. What does it like? Well, it's somehow invisible. It's just like a software you use every day. The court, their network is connected with almost all other government authorities and we say air companies or some other necessary platforms. The court, they can connect with their system and send orders to such different authorities or organs with specific requests. For example, the court can just check or try to track down, find your properties through the online system. They can also freeze your bank account by sending an electronic order to the bank through this system. And everything is done automatically. The bank has no ways to try to resist the court's order here. So it's quite powerful. And in the formal proceeding of enforcement, if everything is done, there is a court judgment needs to be enforced. The court can just send orders to bank to just transfer the money from the debtor to the creditor or to the bank account of the court. Everything can be done automatically. So in China, here enforcement is quite powerful with the help of such online system. And I understand the difficulty of debt collection. The most severe difficulty in debt collection is that the debtor try to conceal or transfer their properties or assets. So with the help of this system, I understand as of about 4 years ago, September 2018, the data is 4 years ago, Chinese courts have already frozen about 300 billion RMB yuan through the help of online system. And they have already conducted more than 747,000 online auctions. The auctions can also be conducted online with the help of online system. And with a turnover of about 500 billion RMB yuan, they have recovered such amount of money through online auction. And also Chinese courts have already restricted nearly 20 million person times to travel by air or high-speed train. So with such a tight net of limiting the dishonest debtors' behavior, China's enforcement has becoming more and more powerful. So that is why we would recommend our clients to try to recover your debt in China. Please be confident and please try every effort to recover your debt. And the final part is also, I think Laura has made very good sharing today about recognition of foreign arbitral awards and judgments in China. As to the practice in China about foreign arbitral awards also is based on New York Convention. And we have very strong support from the Supreme People's Court of China, because in China, such kind of cases are reviewed by local courts, but they have to report to the SPC level by level. If they decide to refuse to recognize a foreign arbitral award, if they decide to do so, they need to report to the SPC and get their approval. So that is a great system to limit the wrong behavior or wrong understanding of local courts if they would like to refuse to recognize foreign arbitral awards. So as the result, such kind of cases was seldom dismissed by Chinese courts because the SPC have the final say. They has the final say. And also property preservation is still available in this proceeding. If you have an international or foreign arbitral awards want to be enforced in China, you can try to apply for property preservation at the beginning when you file the application to court, so as to freeze the debtor's property at the beginning or as early as possible. Okay. And finally, about recognition of Italian judgments in China, Laura said, yeah, correctly, China has a treaty with Italy, but the number of cases is still relatively rare. As far as we know, we have about 5 Italian judgments trying to be recognized in China, and 2 were recognized, 3 were dismissed on the grounds of fraud, because Chinese courts understand such judgments were obtained by fraud. I understand maybe some proceeding was not conducted appropriately. Maybe some investigation were not done sufficiently by Italian courts, and Chinese courts think so. They thought so. Okay. Later, after in this year, Chinese courts, the Supreme People's Courts, they just published a conference summary of a symposium of nationwide courts on foreign-related cases. And in this conference summary, there are contents about recognition of foreign judgments. And China is adopting a much more friendly attitude in recognizing foreign judgments. But since Italy has treaty with China, we still need to review the standards indicated by the treaty first. And if there are some other issues fail to be stipulated by the treaty, we can just check the conference summary this year. So due to limitation today, we cannot go through this part too much. Hope to talk with that later. And also the last point in red, property preservation is also available. So just remember property preservation in China, the possibility. Okay, and that's all for today, for my part today. And this is my email. If you have, if our audiences have any questions on any part, please just send emails to me, and I'm very happy to share anything about China or Chinese law with Laura and all of our audiences today here. Okay,